On here. All right. Good afternoon, everyone. I had a practice run there on mute for a little while. It was a good time. For the afternoon session, we've got digital identity discussion, and we're basically open to direction on this and contemplating what the path is forward, Mr. Co-Chairman. We obviously passed a good piece of legislation that was to serve as a framework. I know we'll hear from some of our stakeholders that I already see are showing up for public comment. We put together a series of definitions and some initial substantiation of those definitions through providing that a digital identity, whether it's organizational or personal, is capable of acting through electronic means on behalf of that individual or the organization. But there's a lot more that we need to do. We talked about a lot of those concepts during the last interim, but decided we'd kind of take a stepwise approach to it and start off with something that was foundational. But now we know we have to work on privacy rights and property rights as they relate to a digital identity. And then theoretically also start getting to some of the things that we heard from Mr. Land earlier Mr. Allen earlier in the day on trying to integrate with digital identity system through the state, whether that's through the Secretary of State's office or elsewhere. So we've got a lot of work ahead on digital identity. Mr. Co-Chairman, some comments or thoughts on where we are on this topic, and then we'll get some background discussion with the Legislative Service Office.
Thank you, Mr. Co-Chairman. I mean, I think that I guess what we're going to engage in is really a process of it's really just going to be a discussion to figure out exactly where we want to go, as you've said, and hopefully build some type of a framework with or add to our framework. So I think just for the committee's sake, if they're on notice, I guess that's what we're aiming for is to have a discussion so we can try to figure out exactly what we want to build onto this. So pretty, I guess, almost informal. It's almost what I'm saying.
Yeah, absolutely. And we've had, I think, excellent work by the working group on digital identity over the last interim. A lot of stakeholders were involved, and we know that this digital identity work in getting to privacy and property rights associated with a digital identity are also what is holding us back in another few fronts. Representative Yin and the work he and his working group did on data trusts and information trusts, for example. We're looking for a better foundation in privacy that was lacking. So we need to get that in place so that we can actually move forward this other project. And I know there's a lot of interest in that. We got a few fundamental concepts that we're trying to rely on. One is the idea of the self-sovereign digital identity concepts that Christopher Allen initiated and has further revised and refined over the years. Those are integral to what we're trying to move forward. We talk about this concept of original authority through the definitions, but it gets back to that self-sovereign digital identity. And Ms. Kaiser is going to join us in some public comment. We know that the idea of property rights and ownership of your data and being able to manage your data is something that we need to achieve, and looking to the California Consumer Protection Act, their amendments, and looking to the European GDPR for some legislative guidance there on things that have been accomplished can be a model for us to build off of. And then there's just a lot more to what direction do we want to go and what programs do we want to enable. So I think we're just open to stakeholder input and trying to figure out, where this thing needs to drive, and listening to as many stakeholders as we can to get there. So it's a huge topic, a lot of work ahead, but we've got a good team of volunteers working with us. I'll pause there and see if there's any comments or thoughts by the committee before going over to LSO. And we've got background summary here, but I don't know how much we're going to get into from the LSO before we start getting to public comment. Anything, committee, at this time? All right. Do we have anything? No, good. Just part of the conversation. Okay. Anything that I did miss, David, in terms of actions we've taken or any legislation, anything that we've seen elsewhere that we should be contemplating?
Mr. Chairman, I don't know, you had asked us to post Illinois House Bill
Yeah.
2,880. I read through that. I could present some of that if you'd like, or I didn't know if you wanted to go over that, but otherwise we didn't have any background, and I don't think you've missed anything else as far as what you've mentioned.
Yeah, we did raise that. We got a link to that. Would you just briefly, 30,000 foot level, run through that Illinois legislation for us that we distributed for the committee, and it's available on the Wild Edge website for the meeting?
Thank you, Mr. Chairman. David Hopkinson, staff attorney with the Legislative Service Office. If you have it in front of you or have seen it from the meeting materials, this is from the 102nd General Assembly, State of Illinois, just a copy of one of their introduced bill drafts. The last I checked yesterday, they hadn't actually passed any of this yet, but it is something that appears to still be in the works. The first part of the bill draft, kind of for the 30,000 foot view here, this is, they have some legislative findings that essentially just talk about, some of the problems that we have in the digital age, the proliferation of personal information, and some of the difficulties that you can have in managing that. And that a lot of data, especially personal data, is now available to companies, and that there can be some concern about the access that they have to that data, and particularly with increases in computing power, improved algorithms, that sort of thing, that there really is a lot of potential negative consequences that could be had from improper use of some of this personal information, personal data. So what the bill draft does, aside from kind of making those findings and pointing out some of those issues, is that on page 4, we start getting more of what the bill started in subsection D, that it provides or expands the definition of digital assets to include, as it says, their information accumulated regarding individuals or entities' personal information, including but not limited to family lists, friend lists, associates lists, relationship histories, writings, photographs, personal interests. So a very broad category of different information: medical history, employment history, including DNA profiles, purchase history. And it establishes that the concept of a digital asset exclusive to an individual or entity should be construed broadly to encompass any information that could have commercial value. So it provides a pretty broad definition for that. And that in subsection E, that after December 31st, 2022, that any access of an individual's digital assets for purposes of commercial advertising, that it would require some form of compensation to that person. And then it provides on page 5 that essentially up to a penny per advertisement, but the amounts would be indexed for inflation. That in subsection F, access of an individual or entity's digital asset by a third party seeking to gather information for those purposes of database collection without consent of an individual is presumptively an infringement on your digital asset. And in the event of such infringement, paragraph 1 provides that you could be compensated for actual damages, statutory damages up to $3,000 per breach for a period of 5 years. Provides that the burden of proof would be on the The owner of the digital asset to only present evidence of the infringer's gross profits. And then it would be on the infringer to prove deductible expenses and elements of profit not attributable to factors associated with the breach. In paragraph 3, that it would be a separate or unfair competition for a third-party platform that has access to digital assets to threaten or deplatform an individual or entity absent notice and a 1-year period within which to transition to another third-party platform site. So here we're starting to get kind of into I guess, more outside the scope necessarily digital assets, digital identity, and the rest of the bill is more along the lines of, as best I can tell, for example, if you are deplatformed from a social media outlet without meeting the requirements of this bill, there would be consequences for that social media or other outlet or entity that's providing that deplatforming. And it provides later on limits for, why they could deplatform an individual. And then it provides some definitions for what deplatform means, for what an interactive computer service is, and that's pretty broadly defined, and frankly would encompass just about any computer service or system. And that would be the 30,000-foot view. Mr. Chairman, I would stand for questions on this particular draft.
Excellent. Thank you, Mr. Hopkinson. And it really is the part of this for contemplation is the language that relates to what they're calling digital identity assets and the association of royalties to those that we wanted to take a look at, or at least have this available to consider, because it does get to the idea that the individual has a property right to all of these concepts, that whether they're created about them or by them, and that there's a consent process that goes along with it. So it's interesting along the lines of the digital identity discussion that we've been having. Any questions about it? Yep. Start with Joel and then we'll go to.
Thank you, Mr. Chairman. Mr. Hopkinson, you were saying that without permission, you couldn't have access, a third party couldn't have access to that information. So I'm just thinking of in kind of practical terms where the use of, say, for example, a social media platform today, you're essentially receiving a service in exchange for the data that they're gathering on you by using that service in kind of in practical terms. That's how it's working, right? So would there need to be a step of relinquishing control of that digital asset to that third party platform, or would a sort of footnote on that platform saying by using, pick your social media platform, you agree that you relinquish control of your data to us, da, 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 da. Does that make sense what I'm asking?
Go ahead, Mr. Hopkinson.
Mr. Chairman, this, frankly, is not something I've researched in any particular detail. My understanding, I would guess, that a company certainly could put in that you would waive certain rights or have waive information, and most of those companies, I think, already do have a lot of that in the fine print. Generally, we give up a lot more than we think we do when we sign up for Google or Facebook or something similar. So they're frankly probably are covered in a lot of senses with that. But this, I think, would get it, if they were accessing it potentially for, say your spouse has signed up, but you haven't, and they're accessing your personal information to collect it from you when you're not on the platform. That could potentially be an issue or those sort of situations.
Follow up, Mr. Reville? Okay. Representative Stith, go ahead.
Mr. Chairman, so if I'm on Google and I'm doing a search and ads get displayed by Google to me based upon my history and what they know about me, then Google owes me a penny for each ad. Is that what this says?
Go ahead, Mr. Hopkinson.
Thank you, Mr. Chairman. I don't think so. I guess that would kind of depend on how broadly you read subsection E there. I'm not sure.
So,
Go ahead.
Mr. Chairman, but it seems to me that let's imagine that it's part of Google's algorithm to always access everything it knows, Google knows about me so that it can target ads to me. I mean, it is kind of scary because if I'll do a search about, buying a briefcase and then I'll get an email from someone advertising a briefcase or whatever will show up in other unrelated apps. And it's a bit scary, current world, but it seems to me that the only way that that's really happening is because they're accessing what I'm doing. And then they pay, and how are they supposed to pay me? I mean, I don't quite, and let's assume that they do figure out a way to pay me. Mr. Chairman, doesn't this just mean that the platform, the digital search engine is going to pass that cost through onto the advertisers? At least I'll try to. And
Sure, Mr. Hopkinson, you can speculate or anybody else can.
Chairman, for speculation, I would imagine they'd pass the cost on to the advertiser. And I mean, it does contemplate setting higher royalty thresholds, but I don't think the bill really addresses the mechanisms for how this would work. And to be fair, this is an amendment or kind of an additional section to existing Illinois law, and I have not reviewed that existing law, so I'm not sure what might already be in place with that.
And Representative Stitt, I think this is just trying to lay out what effectively reverses to some degree the existing process whereby you're sort of told in an end user agreement that you don't read that they're going to sell all of your information irreversibly, irrevocably, and they'll do it so that you can use their site, to something which is more of a formal agreement where you have the opportunity to effectively negotiate in that agreement, and that the requirement, you can see the royalty, you can agree on whatever royalty you want basically, but there's some default threshold as it's structured. And that those would be inflation adjusted or whatever the case may be. But the idea being that you'll continue to own that as your property, that intellectual property is your property. And if they want to use it for some purpose, that they're going to be entering into a more direct agreement with you to use it, and that they have to pay you a certain rate, which is conceptually one of the things that we're trying to get at with the digital identity is to how to enable this and how to, we don't need to get to this level of detail of the numbers. I think they got into the weeds a little bit, but the idea that that's your property right. And that, maybe just an unread end user license agreement isn't sufficient for you to permanently terminate your rights when you're in their web space. So it's an interesting model. Go ahead, Dan.
Thank you, Mr. Chairman. Well, I read this and I go, well, it's kind of a feel-good situation, but in reality, to implement this is going to be extremely difficult. First of all, on most of these platforms, they ask you, do you agree to their terms? And you look at the 5 pages they put out there, and if you mark, no, I don't, then they say, you can't use our platform. So I'm not sure we're going to change that by implementing this bill. And I'm also going, okay, legally, what are we going to do? We're saying we want to sue you. Really, do we want to hire an attorney to try to pursue this action? I don't think it makes sense. So once again, I'd love to have our personal information protected, but I'm not sure this bill is going to solve it. So thank you, Mr. Chairman, letting me express that.
Absolutely. And no, I agree, Senator, that this certainly isn't the answer, but this is something that came up recently, which is in this space. We wanted to make sure that everybody saw what was being considered. I think there's some real challenges with the approach that's being used, but some of the concepts are interesting. Any further questions or discussion on this at this time? And while we're in this topic, which was spurred by, did we have anything else? I don't think we do as far as this material. Okay. Mr. Chairman, if you want to go to public comment now and stay on this topic, I'd invite Ms. Kaiser, I think, who is, very active in this space, and she can provide a little more background with what models are being looked at and kind of how California has done this. So what can be effectuated and maybe a little more context in Illinois. So if we can invite Ms. Kaiser to join us for this discussion. And
Brilliant. Thank you so much.
welcome, Ms. Kaiser. We couldn't hear you at first, but we can hear you now, and you're on. Thank you for joining us once again today.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Brittany Kaiser. I am a co-founder of the Own Your Data Foundation, which is a Wyoming 501c3, educating people on digital literacy and emerging technologies, as well as the Digital Asset Trade Association, which is the Wyoming 501c6, specifically working on blockchain legislation and advocacy. So I'm really actually excited to see this new draft that has been proposed, and that it is congruent with a lot of the advances that are being made in different states and some of the decisions that have come down through federal agencies. So one of the most important concepts in here is the idea that not just we own our personal data as our intangible personal property, where we've already defined digital assets as our intangible personal property in the state of Wyoming. That's also being considered in up to 12 states this year as well. And then looking at further digital asset definitions to include personal data. Now, a term that you've probably also heard very often is the data dividend. So that was first being proposed in California. It has now been proposed in New York in the New York Privacy Act, and it's being looked at in multiple other states. This is the idea that, you could consider it royalties, you could consider it a data dividend, but that we own our personal data as our intangible personal property, and the companies that collect that data from us should do so consensually and should give us a portion of the profits should they be monetizing it. This is becoming more and more popular all around the world. A lot of the different models that are being looked at on a supranational level in Europe, as well as national policy in big countries such as India, are all looking at data ownership and the ability to give individuals a portion of the commercial profits of their data. That is not just a legislative and regulatory initiative. That is a very exciting and burgeoning industry in the blockchain space, especially. There are tons of different very big companies in the market that are already working on models such as this and already have applications and software as a service that are out there and being used, both large corporations as well as public companies. So a few of those examples are, for instance, Brave browser, which I think most people are familiar with in the blockchain space, which pays you for the data that you create while you are searching within their browser in BAT tokens, which you can easily trade for Bitcoin or anything else that you'd like to. There is a company called BigToken, which is owned by Srax, a public company, and that application has existed for a couple of years, and it allows you to be paid for the data that you produce. So again, you're earning a portion of the profits of the monetization from marketing and advertising companies. And Permission.io, which is a global ad network based on smart contracting through the blockchain, where advertisers are not only able to verify that they have actually sent real advertising to real people as opposed to bots or trolls and fake accounts, but also the individual is incentivized to update their personal data profile and get paid for the data that they are creating. This is actually implemented globally and has huge partners such as LiveRamp and Google Ads. So in terms of questioning whether this is viable, that's not really a question anymore. Big companies like Google and Apple are actually very happy to start to protect people's data and pay people for their data. I can't say the same of companies like Facebook, but I'm sure that there are plenty of other large companies that own a big portion of the amount of personal data that exists in some of the world's biggest companies that are considering making this change or have already made this change. So we do have the technology to do it. We already have active big companies that are doing this, and we're really waiting for some of the legislation and regulation to catch up. Recently, we've had really interesting results coming out of FTC cases. And the Federal Trade Commission is starting to say that the terms and conditions that are often used by these big tech companies are actually against consumer protection standards. And so people do not have real informed consent when they're agreeing to give away their data. Usually we have a 40, 50 page terms and conditions that are written in legalese for a common person not to be able to understand. So it's likely that regulatorily, nationally, we're going to see recommendations to change these terms and conditions to bullet points around the 3rd grade reading level and make it really easy to have true informed consent when people are agreeing to give away their data. And given the massive surge of use and adoption of blockchain technology by a lot of the world's biggest companies, especially in the past year, it's going to be very easy for people to start using smart contracting as part of a terms and conditions opt-in. So that data could only be accessed if someone has not only transparently consented, but is acting on a smart contract where they would automatically be paid every time their data was accessed for monetization purposes. So we're definitely getting there. I think that this regulation is just really very much in flow with a lot of the developments that are happening both in the public and private sector, and that this would be very much welcome by everyone should this be introduced. Thank you so much.
Thank you, Ms. Kaiser. Questions for Ms. Kaiser? Go ahead, Joel.
Thank you, Mr. Chairman. Thank you, Ms. Kaiser. Nice to see you again. If the market forces are already underway that you described earlier, whereby there are services that are already paying users for the use of a browser, for example, or there are companies that are electing to self-police, if you will, like Apple and increasingly Google, what legislation is needed? What do we need to catch up to if the private sector or if market forces are making this happen already?
Ms. Kaiser?
Thank you so much. I believe that one of the most important things that we could enshrine into law is that instead of just having our digital assets defined as our intangible personal property, to make a sub-definition of digital assets to specify personal data and the types of personal data. Obviously, the digital identity bill is incredibly helpful with moving forward on what some of that could look like. But additionally, saying that people have the right to a percentage of the commercial value of their data is incredibly important. So far, we've had one federal decision on that, which was in the state of California at a federal court, where Andrew Yang and the Data Dividend Project took Google to court, saying that individuals would have a commercial right to their data, and they won. So that is now one federal decision, which is incredibly exciting, and is starting to follow with more states looking to introduce not just your personal data being your intangible personal property, but the commercial value partially being owned by the individual, not 100% by the platform, which is normally what terms and conditions say these days.
Thank you, Ms. Kaiser. Follow-up, Joel?
No, thank you.
Ms. Kaiser, on the current terms and conditions, you mentioned there's some work being done there. I'm just sort of curious. Again, the reality is, I know everybody's obligated to read all the terms and conditions of any site that they go to, and also read all of the end user license agreements on their software. And there's an implied obligation there, but literally nobody does those things. And you read all the stories about like, if you agree to this agreement, you forfeit your soul to this website that was on there at one point. So a lot of souls were lost that day. There, incredible things have been put into EULAs that are never acknowledged or known about and then laughed about after the fact. Is there any case law or any circumstances to your knowledge where those EULAs have been significantly challenged as abusive, or where the courts have ruled on one way or another strongly and decisively as to whether or not you're fully responsible for everything in them, or whether there is a low expectation of compliance?
Absolutely. So there are now a long list, a string of different cases that have been brought in different states that take up that issue in particular, which is why this has become an issue at the Federal Trade Commission. And a lot of the rulings have come down and said, actually, this doesn't look like real informed consent. And so the FTC is looking at what type of regulation that would be implementable on the compliance side for any company that is actually dealing in the commercialization of personal data. And so this is an open debate right now. I believe they have an internal working group in the FTC that are looking at this. And so we should expect to see public recommendations coming out sometime soon.
And have you seen any other states working on statutes that, for example, restrict what you're allowed to do through a terms and conditions sheet or end user license agreement, so that these are things that you can do, but yet, for example, you can't waive your rights to your data or something along those lines? Have you seen restrictions like that in any proposed statutes?
So there has been an ongoing debate on exactly how technical people are going to get there. A lot of times they're looking to protect personally identifiable information, which is why our digital identity bill, I believe, would be incredibly helpful to adding to these definitions to say that anything that would amount to your digital identity, that you would not be able to sell that, for example. And so that tends to be more of the open debate, to say that, you know, your personally identifiable information that identifies you, you are not specifically monetizing it. You're using your digital identity in order to monetize all of the data that is securely and anonymously connected to your digital ID, but not actually the data points that make up your identity, which would make a lot of sense and is in line with a lot of other legislation that is out there about, you know, the ownership of your person, your body, your identity, and
Right.
ability to sell that.
No, that's great. And that's obviously consistent with conversation we've had about the privacy versus property kinds of concepts, and things that would be negotiable and things that would not be non-negotiable. Additional questions at this time for Ms. Kaiser? And we can bring her back for other questions. I think we'll have other topics that she'll want to weigh in on, but if there are no further at this time, I see Mr. Allen has his hand up. So thank you, Ms. Kaiser, and stick around, because I think we'll have a few more conversations in different areas that we'd like to hear your thoughts on. Again, appreciate your participation. Mr. Allen, your hand was up. Welcome back as always, and the floor is yours.
Thank you very much. Again, my name is Christopher Allen with Blockchain Commons, and go a long way back in this area. I'm co-author of the SSL TLS standard, which means that trillions of dollars worth of internet commerce is protected using these. This is the HTTPS, so I know whereof I speak. I really appreciate the opportunity to give input in the last couple of years, and in particular last year in Chairman Rothfuss's subcommittee or subgroup, I'm not sure what the technical name is, on digital identity. And I'm very pleased with the result that we had in the law last year, and would like to build on that. I have some concrete suggestions, especially in the sense of, given Wyoming's position as a thought leader, but not necessarily yet in a position where they have strong economic power that, say, New York or California has. So I would really like to see in the coming session that we make distinct digital identity, which we've got, different from personal identifiable data, which can be misused in a variety of different ways, versus digital personal data, which is a data asset. I'd like to make that really clear, that those distinctions, because people keep on confusing them. And in things like the California legislation, they don't even mention digital identity. I mean, it's just like, we need to say these are all together. In some places they cross over, but they are different, and we need to clarify that. I want to support Brittany's track of, own your own data and of your personal own data. I do have some concerns that the low market power of individuals to be able to freely negotiate will make it very difficult for them, and that we have to put some constraints on, what people can be asked to agree to. I would like us to basically say that, that people have the right to cancel various portions of an agreement that were not given with real informed consent, which may mean we need to define what is real informed consent. Fortunately, I think Europe has done a really good job on that. Also, I think that even if you do agree to these various things, that a right to for accuracy, to fix errors, the right to move your personal data from one place to another, or even delete your personal data, should be explicit. Like, you can't sign away that right. And I think you can do that because, again, Europe has already requiring parties. So anybody who's doing big business in Europe, Microsoft, Google, Apple, et cetera, already has to deal with this. So we're just picking back on the technical capabilities. We don't have to use their exact forms and reasons why they're doing it, but the technical result is a user who has inaccurate information can get it corrected or resolved. In general, a lot of this has to do with clarity on principal authority. We picked a fairly obscure term for digital identity, which is principal authority, which means at some point the buck stops. At some point, no matter how much you delegate and contract and whatever various different types of things to, there is the natural person or a corporation in the corporate version that is the ultimate authority over itself. And we need to be able to have some clarity on where you have the right to basically say, no, I don't want you to be my guardian of my data anymore. You're not doing a good job and you can't stop me from taking it away from you. We want that, in there. Some of the areas I think we also can do within Wyoming law and their existing Wyoming laws is deal with various issues of theft of identity. The use of private keys to impersonate people or give false testimony or give false witness. I think, the digital side of that is important, both in the data side, but also in digital signatures and things of that nature. Similarly, biometric information when digitized, genetic information when digitized also is very sensitive. And I think your average Wyoming rancher is not going to be particularly happy with what actually is already possible in this particular area. There are states like Illinois that are making some good progress in trying to, say, hey, you're going too far here. In general, I think I like this UNITRAL thing that basically says the actions, promises, rights, and obligations of a person shall not be denied legal validity on the sole ground that they're affected through their digital identity, which is sort of the first principle of self-sovereign identity, which is you're a real person first. And if something goes wrong with your digital identity and somebody wants to deny you something because your digital identity stuff doesn't work, in the end, there's a person behind it, a natural person behind it, and their rights come foremost. I think we should also enshrine that in some fashion. I think there's some funding opportunities. We've already talked about the corporate registration, but I also think that there is a need for individuals to be able to be a digital corporate registrar, and they may be able to do additional things. There was some discussion earlier about e-residency, which would allow for maybe certain kinds of assets, certain other rights to allow people to have their works and or represent other people and have those works and contracts fall under Wyoming law. And finally, I think, a wild card here is that, every, rancher, when he goes through town, isn't expecting he has to give his photo ID and his address and his telephone number and all this kind of stuff all the way through every place he wants to go. We need the equivalent of this in Wyoming, which may mean that we have some kind of pseudo-anonymous proof of personhood, which basically says this person is a person, but we're not going to give you anything. We're going to use zero knowledge trust things, et cetera, such that you only know what you need to know, that this is a natural person. Maybe it's being used by one of those corporate things we talked earlier, where you're trying to prove that a key of that final member is held by a natural person. That could be something that you offer either through the e-residency or some other kind of proof of personhood. And you can do some of the advanced anonymous techniques such that you're just proving that they can't correlate that to your phone number or any other stuff, which makes privacy easier. So I think these are all things, I think, again, at the top, clarifying what is the difference between these three kind of categories: digital identity, personal identifiable data, and the personal data as an asset. Being clear on that, ability to cancel agreements or limit agreements, especially as it conforms with California or EU things. I'm not saying go with their laws, but their ways of their requirements to address their laws are already being implemented by the big parties. We want to piggyback on that. And then finally, these sort of funding opportunities for e-residency, et cetera. Thank you.
Thank you, Mr. Allen. I think it is worth noting, and it's important to note that anything that's under California's CCPA or under the EU's GDPR, the major companies are already capable of complying with technologically. So we're definitely able to operate pretty freely under that umbrella if we think they're good choices, and there won't be a barrier to industry adoption in those spaces. It's when we get outside of underneath that umbrella and make decisions that would require compliance policy by industry that we might have challenges. Questions for Mr. Allen? Go ahead, Representative Western.
Mr. Allen, Mr. Chairman, thank you. I'm going to ask a really, really silly question. You're talking about the difference between digital identity and personally identifiable data. Just in real simple terms, maybe lay out some examples as differences. Like, are we talking, if let's say you take a digitized version of my face with my facial features, I assume that's digital identity, or would that be personally identifiable data?
Go ahead, Mr. Allen.
Well, it is both. It kind of falls into both categories. Again, it's kind of a Venn diagram, but I think the better example is someone was able to use where people were delivered in taxis to basically determine that they had spent time at a strip club in New York City, just simply by taking the personal identifiable information, correlating it with other information such that they knew where people were in the various parts, and then we're able to say the person visited a strip club. When you get to the point where certain kinds of information can be strongly correlated to make inferences about your behavior and things that you didn't, this isn't, you can kind of argue if you buy a donut from me, a box of donuts digitally from me, I have a certain right to say, yeah, you bought digital donuts from me, right? It's a completely different thing when I can basically use that inference or whatever and make money to sell to an insurance company that you are fat or eating unhealthily. That's when we've abused the personally digital identifiable information. So, my contention is we need to draw some lines here. I think some of this is, again, already happening in EU and other places where we have some mitigation that we can address that don't require them to create new mitigation. It might be for a slightly different cause or under a slightly different legal principle. But we want to avoid these abuses.
Oh,
help?
go ahead.
Mr. Chairman, Mr. Allen, no.
Okay.
I said, just for the deeply uninformed person that I am, really just try to lay out the difference between the two, because conceptually, kind of follow what you're saying, but like I said, maybe some really clear examples of like, this is personal information, or this is digital identity, and this is personally identifiable data.
Go ahead, Mr. Allen.
So, yeah, I wish I had some better examples, but I think, you know, one of which is your driver's license. Okay, so the driver's license has your photo on it for a reason, which is to allow the authentication by the police officer who's pulling you over that you are that party. So that allows them to authenticate who you are, which is separate from the little seal on the license and the date and other stuff, which is that it authorizes you to do something. Similarly, you know, there are lots of different little bits of information that, you know, there's an expectation that when your daughter goes into the bar and shows that she's over 21, that personal data that's on there, that address and telephone number and whatever, is not going to be taken by the bouncer to now stalk this young woman, right? I mean, that's a real world expectation. We want these same expectations to be enforced in the digital world, where they can make all kinds of inferences around things, and we just need to be super careful about those correlations, which is different than maybe the economic things of, hey, you know, I'm buying patio furniture because my you know, my patio is much more sunny this summer, and I'm going to be around it a lot more. And you know, I ought to be able to maybe get a discount from various parties who are all negotiating and sharing information about the fact that I want patio and furniture. So I think that's a very distinct thing in you know, in the use of the data for commerce, and of which, you know, where Brittany makes some very good arguments, this stuff can be misused in commercial terms, and you ought to be compensated for it and be able to manage it, et cetera. But there's these other forms where it's being used to, you know, stalk people or you know, do things that they didn't agree to. I mean, most of the data about you is not stuff you signed a EULA on. Most of the data is, oh, we kind of got this little bit of personal identifiable information about you and this package of data around it. We've got this little bit of personal identifiable information, the package around it. Oh, you're the same party. Now we've got this huge giant package of stuff that we can use to manipulate you, to maybe try to persuade you to vote you know, against your own interests or lie to you in very special ways, et cetera, which is something Brittany has been, you know, been very much a witness and has offered testimony on. We want to stop that from happening. So separating the identifiable information from the personal data as much as possible is important.
Again, Mr. Allen, did that help?
Yeah.
Yeah. All right. And I mean, the key bright line there is the personally identifiable information is the information that ties, or is data that ties directly to you. So I can determine, you know, you give me 5 different pieces of PII, maybe each of them individually I can't get back to you on, but with them together, I know it's Representative Cyrus Western. The digital personal data is information then that can be linked to that person, but doesn't necessarily tell me who you are. So if I know what you had for lunch, that doesn't necessarily tell me who you are, but it might be valuable information once I know who you are about your consumer trends. And oddly enough, you know, if you give me enough of the digital personal data, I can still figure out it's you. So almost any digital personal data, if you stack it up high enough, starts to become personally identifiable information because it builds enough of a digital footprint on you that I can track back. And that's always a concern, is what our PII today is versus the digital personal data may change over time, and it may change with quantity. you can do a fingerprint is obviously PII, but if I have 25 data points and you're the only person that could fulfill those 25 data points simultaneously, then all of a sudden it becomes definitive.
Also, to be clear,
Go
there
ahead.
is a lot of new zero knowledge ways of doing this in the digital world that aren't possible in the real world. So we can basically create an identifier that allows the data to be used as you want it to be used, but can't be correlated with other data that you have. But that requires, special handling of the data. And that's why we need to be clear. These things require special identifying information for them to allow to be correlated. Limit that correlation, limit it now. So.
Thank you, Mr. Allen. Additional questions for Mr. Allen at this time? Any additional? All right, well, stick around, Mr. Allen. We'll go through a
Thank
few
you.
more thoughts and potentially come back during the discussion. Thank you. And we are targeting 3 o'clock end time today if we can, 3:15 hopefully at the latest, to be done to get everybody on the road. So we're exploring the space. We won't necessarily have any significant actions to take today, but we just want to get informed about what the path forward is going to be. With that, Mr. Greenwood, I see you up there. Come join us, and we appreciate all the work that you've done with us on digital identity and the participation in the working group and all of the hard work you've provided us. So welcome once again to the Select Committee, and let's kind of hear your view of what the road forward needs to be on our digital identity work.
Thank you, Mr. Chairman, members of the committee, and other participants. I'm Daza Greenwood, and I appreciate the opportunity to share some remarks on this topic. I would like to suggest first the one way forward that we left off talking about in the last session that I want to remind you of as potential next steps is less sweeping than dealing with privacy and personal data, but maybe doing a little bit more wiring of this building block of a definition of digital identity to some other sections of Wyoming law beyond the Uniform Electronic Transactions Act, where it's already pretty well connected. And so just as a reminder for future work, there were 4 other areas that were under consideration, but I think we may have timed out, and I'll mention them now briefly. One of them was the Wyoming Uniform Fiduciary Access to Digital Assets Act. That is the law that simplifies and streamlines the dreadful process when a loved one has passed away, or when someone's passed away and you have the duty as executor or personal representative, for example, of winding down their affairs. That part of it where you need to get access to their PayPal and their bank accounts and their LinkedIn to let people know they're not coming to the meeting, and just all of these accounts, including assets, but just life management is difficult, and it's a terrible time to have to go through that. So this act creates a more standard ramp for that process for fiduciary access to digital assets generally, and identity is at the center of that. So being able to recognize that the account holder who is deceased in particular, I'm sorry, this also applies to other fiduciaries as well that you may delegate power to, that the account holder has this kind of digital identity, this Wyoming personal digital identity. That is the identity through which they have the digital assets, and that they can delegate some authorization to their fiduciary using this definition that's now in Wyoming law, would be a perfect match for the process that they are sort of lurching toward in the Uniform Fiduciary Access to Digital Assets Act. There wasn't a definition of identity to point to. Now there is one of digital identity. Another one is, actually, I won't say all of them. The other big one, I think, is distinct from the Wyoming identity theft statute. It's section 6-3-902 of the Wyoming statutes, and it's unlawful impersonation through electronic means. And it provides some penalties for that. And so in it, there's just including there wasn't a definition of the personal digital identity that is being unlawfully impersonated, and that creates some criminal and other liability under that statute when it was written. Now there is one, so doing a little update to cross-reference there would also make a lot of sense. I won't get into it, but we might also look at if the work group continues this session for digital identity. The work group may also want to look at the guardianship provisions and the conservator provisions in the probate code. There may be some appropriate fixes there, and then I'll leave that right there. So that. Now, may I, Mr. Chairman, may I take another moment to make a couple of remarks, I hope clarifying, on this kind of open question about the distinctions between personal digital identity and personally identifiable information or personal data?
Absolutely, Daz, although I think Representative Westwood stepped out for one moment, so timely, but go ahead.
Okay, well, maybe somebody can mention this to the representative when he returns, but the way I look at it, the key functional difference in the definition, which partly makes this definition so good and a real model for other states, is that this is the personal digital identity that the individual can communicate or act through. Which are very active words. And so I think the center use case is an account. So when we use like our Google account to communicate and to work on documents together and to calendar things, we're doing that through digital identity. That this one's provided by Google, and it very arguably is not under our kind of sole dominion and control, or it's not of, by, and for us completely. It serves other interests. Our principal authority, the principal authority for a Google account, if you read their terms and conditions, is Google, and it's our privilege to be able to use their identity system. But so by contrast, the personal digital identity is one where we have principal authority over it. So for example, if we just generate a public-private key pair in a blockchain wallet, that's a really good way to have a functional system that can act as the means to log into a system or to sign messages or communicate and act. We could use Keybase. I think the Select Committee is familiar with a lot of different technical solutions. The main thing is it's self-sourced identity that resolves to the individual. And I think that's the main kind of difference. Then on the other side of the spectrum, you've got the data about people. You mentioned location data, Mr. Chairman, or I'm sorry, Christopher Allen did, and our communications data and data that we generate and data about us. This is personal data, and I think that one of the places where it really comes up is with the CCPA, and the GDPR, and the California Consumer Privacy Act and the General Data Protection Act in Europe, and the provisions specifically that deal with what are called DSARs, or Data Subject Access Requests. So these are the rights we have under the California law and some other states now, and GDPR. And under other privacy laws as well, like the Federal Privacy Act, for example, every US person has this right for data that's held by a federal agency. This is the right to say, give me a copy of my data, or in some cases, correct my data. Or in the EU, and CCPA delete my data, and under CCPA don't sell my data. So these are rights where an individual can exercise these rights with respect to their personal data. So it's about personal data, but you need the identity to do it, because they have to know whose personal data are we talking about, and more to the point, there's real risk and liability in having the wrong person ask for these things if they're trying to be a nuisance or fraudulently get your personal data. So we need to be able to resolve to the correct endpoint, as it were, of identity, and then layer on authentication and authorization to that identity. But the rudiment here, like the basic legal building block, is the personal individual digital identity in those contexts. So those are some of distinctions and some key ways functionally that they interact, I think. So that concludes my remarks. If there's anything, I guess I'll just say, I think that this legislation that was enacted is the best digital identity legislation in the world. And as I've said on TV shows and things like that, the United States, other states should use Wyoming as a model and should enact their own. But, that's up to them. I think the question for Wyoming now is, what wonderful things can people do with this legislation? And I can hardly wait to see what's possible. When there's another hackathon, somebody should email me. I'd be happy to get MIT teams involved and other people that are really into digital identity to start building out some solutions that align to this critical legal fundamental definition that you have. And I just want to congratulate the select committee on having crafted it and having it signed into law. Thank you. That concludes my remarks.
Thank you, Mr. Greenwood. And before we get to questions for you, this year's Wyoming Hackathon, the Stampede, is the week of September 20th. So it's the 21st and 22nd are our committee meeting. The 23rd and 24th are a business and legal day, Stampede days, to get some background information. And then I believe on the 24th through the 26th is the official hackathon, if I have all of those dates correct. And it's, is it stampede.io? That's not quite right. Is it stampede.io? That's what I was missing. Wyostampede.io is where you'll find the updated information. So we will look forward to seeing you there, Daza, as well as obviously in the time in between. And with that, welcome back, Representative. Daza just answered your question in fine detail. Any questions for Mr. Greenwood? Go ahead, Senator Furphy.
Thank you, Mr. Chairman. Well, I'm trying to get my arms around all of this, so my questions may be pretty basic, but in those states that have passed some of this legislation, have any of them instituted class action lawsuits against some of the big firms? That's my question. Thank you.
Daza?
I'm not sure I know the answer to that question. I know that there have been class action lawsuits related to the subject matter in states and the European Union that has the statute, but I don't know. May I ask, are you asking if the state has? I'm not sure exactly what you're asking. I'm so sorry. Could you clarify? It sounded like you're asking if the state has created a class action lawsuit.
Go ahead, Senator Furphy. Clarify.
Thank you, Mr. Chairman. Well, I'm just asking the purpose of this legislation. What good is it going to be to the citizens of our state if we pass this legislation? So I'm asking, have other states pursued and try to help their consumers against some of the big media companies? That's where I'm after.
Daza, go ahead.
I see. Okay, thank you for the clarification. I'm sorry, my fault for not getting it the first time. Yes, The two that I would think off the top of my head, and I would very much hope that Brittany may be able to add more depth. This is more her area, but the European Union has, well, the legislation they have is personal data protection legislation. They don't have personal digital identity legislation like what Wyoming has, and what was enacted last session. But they do have that, and I know that's been the subject of conversation, and I mentioned it myself. And they have created some enforcement actions on behalf of consumers to compel companies' compliance with the rules of GDPR. And they actually just saw in LinkedIn this morning, there's two more cases now under what's called Schrems 2, which was cross-border data sharing with the United States that used to be under a safe harbor, which has been kind of overturned and created some uncertainty there. And so I understand that there's some enforcement actions now that may involve US companies. I'm not sure, I haven't seen those cases. The other one is California. And the question is, has California pursued consumer protection actions? And they have. I know their attorney general has done that. I'm not an expert in that. I think the main thing I would offer is this digital identity legislation really isn't about class actions or consumer protection per se. It's merely about ensuring people have, and we can refer to their digital identity, and other substantive areas of law, like you can make a contract with your digital identity and enforce it or have it enforced against you, or you could have consumer protections, or and so on, are really outside the scope of the definition of identity. I think the issue that was solved last session was that there was no definition of a individual's identity. It was just simply that the laws had not been updated since people started existing primarily online in commerce and with government and social media. And so it was an absence as a building block to just be able to articulate other areas of law. And so that definition was created. I hope that was somewhat responsive to the question.
Thank you, Daza. Senator Furphy?
Thank you very much. Appreciate it. Thank you.
Excellent. And Mr. Allen, I see you put your hand up. If you wanted to weigh in really quickly, it's I suspect you've got an idea of additional class actions to contemplate. If you're handy.
California. Here we go. California is, has some approaches to how it does its legislation that I think give it less power. Basically, the Attorney General's office can pursue $2,500 per person, type penalties for violating the various rules and notification requirements and things of that nature under their bill. But I don't think that they've strongly funded that organization, but otherwise they have some ability for individuals to bring those up as well, or individually, collectively to do it, which is worrying to some people because, most of the proceeds of that will go to the attorneys doing the suits. I think the real power in the GDPR is that they're based on annual turnover and can be as high as 5% of gross worldwide profits. And they have done some, very, very large penalties against companies that have violated that. And we think there are going to be more. I think they're slapping people on the wrist a little bit now and saying, we're beginning to get serious. The deadline was 1.5 years, 2 years ago. And we're going to start bumping up these fines if you don't get into line. That's it.
Thank you, Mr. Allen. Appreciate it. All right. Any further questions for Mr. Greenwood or Mr. Allen? But go ahead. Representative Yen, back to Mr. Greenwood, perhaps.
Yes, Mr. Chairman. Thank you. Mr. Greenwood, so I was taking a look when you mentioned the specific rights that the CCPA kind of secures for a person's personal privacy. And I'm wondering, because one of the easier things for us to do would be do something that falls under the CCPA already. do you think it would make sense for Wyoming to have similar rights outlined for the kind of rights that they outline in the CCPA?
Go ahead, Mr. Greenwood.
Yes, thank you, Representative Yin, for the question. Personally, I do, however, and I just hasten to add, I shouldn't even take this off. I'm speaking in my personal capacity, not on behalf of MIT or anybody else. I think that California is a bit regulatory, and it seems not in the right style for Wyoming, and a little more regulatory than is my taste or what I would recommend myself. So what I think might be appropriate would be something shorter, but nonetheless getting to the fundamental rights of people should have the right to have a copy of data about them. I mean, that's a basic fair information practice. And to correct it at least, do not sell is getting really into certain types of economics and political ideas about surveillance capitalism, which may be correct, but I think require a lot more conversation and consensus building perhaps. But the main one, in my view, if we look at the fundamentals of the economy going forward, is data, our personal data is definitely an asset class. And now you've got a terrific digital asset statute that would cover personal data as well. And the owner of big troughs of personal data are the people that the data is from or that it's about. In many cases, of course, other people also have ownership interests in some of that data. But what about the person? How do we, but being able to get a copy of our data, put it into a data store, have it available to analyze, to maybe do economic things with, but just to know it, to have it, to use it, to be aware of it, has tremendous value. It's going to be one of the underpinnings of the next economy. And right now we need a law to ensure that people can exercise their rights to have a copy of it. And that arising from the digital identity legislation, I think makes sense. The only other thing I would add to that is there's a part in the CCPA that I've been dealing with a lot lately, and I believe I can say sort of publicly on behalf of Consumer Reports, I've been working with them on a new protocol. It's called the DRIP protocol, Data Rights Interface Protocol, and it basically provides a standard, a messaging standard to make it simple to for consumers to exercise their rights. Right now, the processes are really different from site to site and company to company. So this is just creating like a button or the equivalent of that you can click to get a copy of your data or other things like that. One of the issues under the California law has been how to identify and then authenticate individuals. And the authentication's happening now again and again and again in all sorts of different ways with different companies. If there is a way to do a little better than that, now that you have a personal digital identity statute, to provide sort of a simplified, streamlined way that people could identify themselves and verify their identity when they're exercising these rights with reference back to the definition of their identity, I think that would make it much less burdensome for companies to comply with and much more usable for people to exercise their rights. So my short answer is yes, it's a good idea to do that, but maybe do it a little bit simpler than California.
Thank you, Mr. Greenwood. Follow up, Representative? No, good. Any further questions for Mr. Greenwood? All right. Seeing none, let's get to Mr. Marr and invite him to provide some comments. And Brendan, let's keep the comments to about 10
5
minutes if you can.
10 minutes. Oh, 10 minutes. Oh, great. I can do wonders.
Well, all right, no, 5. You said 5. That's fine.
Oh, you're killing
That's
me.
5. We'll focus on the 5 in an attempt to get everyone out of here about 3 o'clock or so. But go ahead, Brendan. Thank you so much for being here once again. The floor is yours.
Great. Thank you. Once again, my name is Brendan Marr. I am an MIT Media Laboratory alumnus and computer scientist. I am on the working groups for digital identity and also the DAO supplement. What I would like to do is provide a little bit of context in terms of implementations and a micro discussion about the what was in the Illinois Act, but really get to a path forward and the things that were said between Mr. Greenwood and Christopher Allen and everyone else involved. So a couple salient points. So the first salient point is that the Illinois proposal, they have a lot of interesting things, but by and large, it's just not practical or implementable because on the back end, from a computational standpoint, there's no really any way to know what's going on with algorithms and how the data is used and how you can actually prove that those companies would owe you money. I think that's pretty clear at this point. If we were to say anything regarding that a company does need to pay some kind of royalty for advertising, we should, I think, look towards a Hamiltonian kind of move where we should declare that payment be paid in some form of digital currency, and that would force a migration towards cryptocurrencies, which might be kind of interesting and be a small revolution. But to get towards what's going on as far as implementations in the industry and give a little more light on these things. So in a fully decentralized world where we're going, what you have is a remaking of the internet where there are all these decentralized nodes and data which originates at the source of a user, say their phone or their computer, is able to obtain a cryptographic hash, and that could be bound to a key as identity. So there are ways to be doing this going forward, but really the holy grail is getting at and defining what DAZA has expressed, which is the idea of verifying and looking towards defining further principal authority. And we've spent a tremendous amount of time looking at principal authority and why it's important and how it could be used potentially with data trusts. And the next question here is defining that implementation. But a path forward is this, and these are my recommendations. They are three. The first segmentation is what we need to do is be clear on where we are and how we are defining these things. The Digital Identity Act is a great place to define where and what rights are. But at the end of the day, we have to look towards how things are actually verified. How do you actually prove principal authority? How do you prove that you have control over something? And this is something that is probably more apt to be defined in what was mentioned earlier. What I proposed was Computational Law Act, because it is much more along the lines of looking at an implementation rather than a broad definition of rights. Going towards what Christopher Allen has discussed, which is also really, really salient, is these ideas of zero knowledge proofs and how you could do really wonderful things like taking your identifiable information, your address or your age, and putting those into these kinds of systems, these kinds of DID systems or zero knowledge proof systems. And then again there, the important thing to work out is this idea of validation and proving principal authority and control over these things. So going forward, I think the path is separating out the rights and putting that into the Digital Identity Act, and the implementation, the proof and how that is done, because that is much more complex and it involves lots of other things more than digital identity. and putting that into a computational law act, because that's actually breaches upon other kinds of things such as digital identity for entities and registered agents and all of the things that Christopher Allen and I have been talking about in terms of series LLCs and identity for organizations. So that gets to be beyond the scope of a definition of digital identity and more towards these broader issues. And again, we kick these things off with a really wonderful area and potentially a working group, which occurred yesterday on NFTs. And lo and behold, much of that discussion was about what we're talking about here today: rights, assets, ownership. How do you prove these things? How do you define these things? So all of these things work together. And that's why we really need to look at what we're putting in each of these different bins, because they have different purposes. I will concede and let anyone ask any question they'd like, and hopefully I'll be able to answer. Thank you very much.
Thank you so much, Brendan. Any questions for Mr. Marr? Questions for Mr. Marr? Brendan, one that I have kind of gets back to the central theme that we've been talking about, which is, which rights can we instantiate reasonably and have them be effective, what we should prioritize moving forward. You mentioned that we should be clear on the definition of rights and some of these key concepts and worked on the digital identity. But, if you had your first choice, the first thing that we should tackle with regard to adding some rights or substantiation to the digital identity, what would that be in your mind? What's the most important next step?
Oh, thank you, Mr. Chairman, for asking that question. It's a very good place to start. In the Digital Identity Act, I think you broadly define what those rights would be. And they're all of the rights we know of, the rights where an individual has provenance over their own digital identifiers, things like age and the address and all the common stuff, but also all of the other broad rights, the rights to have their data, to own their data, to lend their data out, to do other things such as have control over how that data is used or displayed, or all of those things, right? So those things would be defined in the Digital Identity Act. The NFT Act, whatever that might be, or whatnot, that would define how those things are embodied around ownership, and we'll leave that part alone at the moment.
Right.
The crypto, the Computational Law Act, that would actually get through this other part, which I think is really important, which is something which I'm defining as cryptographic attestation, and I'll hopefully in our next working group down the line, I'll talk more about this. But cryptographic attestation is the implementation of how do we prove that we are making an attestation about something that we have control over. And I think that's the segmentation.
Gotcha.
I hope that is helpful.
No, that's perfect. And I'm happy to hear it's consistent also with what everyone else has been recommending, with clearly providing delineation between personally identifiable information concepts and then personal data concepts and getting at those core principles. So that's handy. Go ahead, Representative Western.
Thank you, Mr. Chairman. Mr. Marr, you said that defining that concept of principal authority is really, really important. And I was wondering maybe if you could just touch on that a little bit more, and certainly in relation to what we're talking about here.
Go ahead, Mr. Marr.
Oh, sure. And after I go, I will also call on Daza to expound upon it as well. So principal authority is the idea that there is somebody who has authority to have control over aspects of our identity, whether it be an individual or an organization. And this becomes really, really important. It goes towards much of what Brittany has been talking about in terms of data and data rights. And because we have another problem here, which I don't think we've figured out, and we're going to need to solve. Right, with an organization, it's very simple. Right, you have an organization. That organization creates an entity, and it's pinned to the Wyoming jurisdiction. But what about digital identity? I mean, it's all great if you actually live in Wyoming and you have a wrench there. But barring that, how do people who are not in Wyoming actually, prove that they are actually have a wallet address or other aspects of their digital identity, however you want to define that, pinned to Wyoming so that the Wyoming laws can apply, right? And I think it's something along the lines of, well, if we have a data trust or some other entity where we can say this has provenance over, this data kind of binds that personal information or personal identifiable information to Wyoming as a jurisdiction. So I'm getting a little ahead of myself, and I want to concede and let Daza expound upon this.
Thank you, Mr. Marr. Daza, and one thing I'll do right now, we've got about 15 minutes left, and I do want to do a quick once through and get some final comments from some of the folks to wrap up. But before we do that, do we have anybody else on public comment that we haven't heard from yet that I just haven't seen on screen?
Mr. Chairman, those are all the folks that previously signed up for this item. I do see that Mr. Kopcho signed on to the webinar, but his hand isn't raised, so I'm not sure if it would be appropriate to admit him.
Okay, Rich, would you send a note if you wanted to weigh in on digital identity, please? And if so, we'll get to you in a moment. But if not, let's go to Daza for a little more discussion on the principal authority. And that concept was actually the idea of Professor Claire Sullivan, who's a member of the Digital Identity Working Group. And I think she's probably sound asleep right now, I would hope, in Australia, if I'm not mistaken. So we'll have Daza pinch hit on that. But Daza, also wrap up a little bit if you have any last thoughts and try and get us about a 2-minute closing from you if you can. Thanks, Daza.
Yes, thank you, Mr. Chairman. Thank you, Brendan. Very briefly, the phrase principal authority within the definition of personal digital identity, and also, by the way, the parallel definition for organizational digital identity is carrying a fair amount of weight. And the function that phrase serves within the definition is to describe the relationship, if you will, between the person, the human, natural person, or the corporate person and their digital identity, their personal digital identity, or their organizational digital identity. And here's to give you a quick basic idea of what that relationship was. The first words we tried was control. So the personal digital identity is the identity that the person has control over. It's an intangible representation, blah, 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 they have control. We didn't like control. It raised issues of property law and had some other legal traps that we learned about. Then we tried dominion. It's like, oh, well, they have dominion over it. That had raised other legal issues, I think, with assets and things that Carla Reyes mentioned. When we tried a few things, we tried self-sovereign, because that kind of has the idea that it's yours and it comes from you, and it's like you're the king of your identity castle, I guess. But then the word sovereignty raised questions about, like, isn't that in law pretty much a state actor or a, like a king or an emperor or something? We liked aspects of it, but in terms of the actual jurisprudence, it raised like lines of case law and thinking that didn't really make a lot of sense. Sovereign, especially when you get into tort immunity and stuff like that. So we ended up on this phrase, principal authority, to carry that water, to express that idea that I'm describing. And I really like it. I actually think it was one of the best outcomes of all of that hard work that the work group did. And it arises fundamentally from the area of law called agency law, that describes a principal and an agent and a third party. And the idea of principal authority is the source of the authority that a principal has when they delegate authority to an agent to operate on their behalf is principal authority, at least in Australia. In the United States, I don't remember ever having used the phrase principal authority to distinguish the authority coming from the principal, arising naturally from them, and to distinguish it from the authority that's been delegated to them from the principal that an agent uses when they're like making a contract offer on your behalf for a house or doing something for you. They have a kind of delegated authority. Principal authority like naturally arises from a person. You're like born with it. It's like free people in free markets have principal authority, and they can keep it, they can exercise it, they can not exercise it, they can delegate it. It's theirs, it's the birthright. So that's sort of the idea of what we meant by that term. And that's exactly the term we wanted when we're talking about a citizen, resident, like humans' relationship to their identity, including their digital identity online. Like if we were to vote one day, or if we were to sign a petition, even if we were signing contracts or doing things from us, to consent to be governed, this is us. And it kind of hints at ideas of natural law and the basic social compact upon which the nation was founded. Thank you. Oh, I'm sorry. I don't really have a 2-minute. I think out of a sense of compassion, it being Friday, my final statements are, I hope that there's a work group that continues, that we can continue to take guidance from the subcommittee, from the select committee on how to further refine the statute if you feel that it should be refined. And thank you for the opportunity to speak.
Yeah, there will definitely be a working group, and you'll definitely be on it, Desmond. So thank you for your service on that. Representative Western, any follow-up on that? You good? Okay. Other questions for Daza? Senator.
I have a quick follow-up. Thank you. Good to see you, Mr. Daza, again. Interesting, the concept of principal authority found in Australia as indicated, and hearing your explanation of it, certainly unique. And just a question as to why you don't think that concept is in American law related to agency. We have a parent authority, an actual authority, but then it sounds totally different than principal authority. And why don't you think that we created it like Australia did?
Go ahead, Des.
I don't know. I'm actually in the middle of a research initiative right now using Westlaw, and I'm asking some of my colleagues that are law professors in Australia to see if we can get back to the roots of like, where did this arise? When was the first usage of the phrase? I mean, now that I know the phrase exists and I've read it, it sounds like we should start using it in the United States too. It's a good way to describe the authority that comes from the principal. I don't know why we didn't have the phrase, but I'm glad we had an Australian on our subcommittee to share it with us, and perhaps we should start using it. And in fact, we have. Like, America now has the phrase in a statute that you made. So we've now introduced it into American jurisprudence, and I think it's a positive addition.
Well, we look forward to this, what I suspect is going to be an interesting journal article when you're done with that investigation. It will be. Anything else for Daza? No. Thank you very much, Daza. Appreciate it. And let's go through final thoughts. Ms. Kaiser, Mr. Allen, any last thoughts before we close up? Ms. Kaiser, go ahead. I see you.
Brilliant. Thank you, Mr. Chairman. Thank you, members of the committee. And again, thank you for having me speak today. My name is Brittany Kaiser, and some of my concluding remarks would be that I would like to put on the record what a positive reception the entire community, the blockchain community and the privacy and data protection community, and you could even call the wider global digital identity community as well, has had such a positive reception to the fact that this law has passed. and that there is now a bill to reference an entire body of work that has been going on for a very long time, and so much money that has been invested into building these particular solutions. So I certainly know that there are tons of companies of all sizes, from, as I said, public companies down to startups, that that see this as an incredibly positive next step for the industry and for the solutions that they're building, and for legislative and regulatory acceptance of what most of us in the industry see as inevitable technologies. I'd also want to put on the record as well that one of the most interesting use cases that I have come up with so far, and that there is tons of industry interest in using this bill for, is specifically to start digging into being able to differentiate between actions that have been taken online by you through your digital identity versus fraud that has been perpetrated in your name. I would say one of the most unfortunate afflictions for a lot of people in the blockchain industry has been impersonation, especially on social media and many different communications platforms. Most people in the industry will tell you that if this has been a problem they've experienced, that they have likely seen zero action taken by social media companies and messaging platforms when people impersonate them. So the fact that the digital identity law specifically says that an action can only be attributed to a natural person if it was that natural person that took that action through their digital identity, I really believe that we could flesh that out, and that could be used particularly to protect not just people in this instance, but for wider online fraud. So I really think that is something that it would be interesting to develop in our ongoing sessions of digital identity, and how we might be able to add some amendments or further definitions that would allow individuals to protect their own rights and be able to take action when other people have been impersonating them online and committing fraud under their name. So again, thank you so much, everyone that has done so much work on all of this. And I'm really looking forward to not just continuing to participate in the digital identity working group, but being able to push forward now on our work on personal data in a working group. And although I wasn't able to publicly comment yesterday, I would also love to join the NFT subcommittee as well,
Right.
Where I've been doing a lot of work in that space. So thank you again for having me, and everyone enjoy your weekend.
Thank you so much, Ms. Kaiser. Appreciate it. All right, Mr. Allen, I see you've joined. Quick final thoughts, wrap up, couple minutes.
Yeah, so thank you very much for your work and your invitations for me to participate. I've been testifying at a variety of other state and international bodies, and I've really appreciated the hands-on work and the effort to understand this very technical and complicated new area by initially the Blockchain Task Force and now the Select Committee. So thank you very much for diving into this area and being effective. That's why I keep on coming back. It's because you get shit done.
As we do.
I think the one thing I would like to add is that we maybe pull the special protection for private keys, at least the intent, into the identity committee. It didn't really have a committee. For me, it's a heck of a lot about false witness, identity theft, signature without your authority, things of that nature. It can only be done if people are careful with their private keys. And even the Electronic Frontier Foundation CTO said, hey, it's about time we give special protection to private keys. Maybe the previous form that we used got too confused with civil forfeiture and other different types of things. But at its heart, for me, is it's the core of what allows you to prove your principal authority. So if we can maybe bring that former bill, which has been proposed 2 years now, to this group to figure out how to make it fit and work and pass, I would love to see that happen. So thank you very much.
Thank you so much once again, Mr. Allen. Appreciate it. All right, we have no further digital public testimony. I believe we've hit everybody. Is there any public testimony, or did Rich show up?
Mr. Chairman, yes, he has raised his hand if you'd like. me to
Gotcha,
admit
sorry
him.
about that. Go ahead. Yeah, let's bring Rich in real quick. Get his public testimony and then go to the room.
Mr. Chairman and Select Committee, thank you for hearing me. I just want to tie a few things together, from NFTs to DIDs to DAOs. If you think about the future, I'm going to be a member of a DAO with my DID, and I'm going to accumulate my NFTs with my DID, and that is going to be my portfolio. And I will do that in the metaverse, in the open metaverse. And if I can do that in a way that has Wyoming as the certificate authority that validates that I am who I am through my DID, then that is nirvana for me. And I think that putting forth those kinds of concepts and ideas is really what we should be doing in terms of laying the groundwork and the laws that will cement that. Thank you for hearing me.
Excellent. Thank you, Rich. Appreciate that. Questions for Rich? I thought I was going to rhyme there for a couple of minutes there, Rich, honestly. Little disappointed with the rhyme scheme. All right. Thank you, Rich. Appreciate it.
Yep.
Okay. Any public testimony from here in the room? Any public testimony? Seeing none, public testimony is closed. Back to the Select Committee. So we don't necessarily have any actions that we need to take today on this. This was largely informative, trying to figure out what the path forward is. I think we got a lot of good feedback, and then we'll have to have a working group on this. What we need to do now, though, really is kind of contemplate the steps forward. And Mr. Co-Chairman, I think we need to assemble a few more working groups. We don't need to do that right now. I think circulating by email, trying to gather interest and trying to load balance everybody's time, recognizing that we've got some good experts that are going to engage as well, and just figuring out what we need to do is probably the best path forward. Joel, go ahead.
Yeah, thank you, Mr. Chairman. I having been on the subcommittee during the last interim period, I kind of realized something today that might be an interesting thought for us to think about, which is that there is a line that I don't think I quite appreciated before between the self-sourced identity and the third-party sourced identity. So and to me, that kind of begs this question that was asked earlier, which is, what can we do that will benefit Wyoming or the people of Wyoming, and what would we do that wouldn't necessarily benefit Wyoming or the people of Wyoming? And I think that if I think about this notion of a self-sourced identity, of creating something that is your own contained and created vessel of your information, and then Wyoming applies these very good privacy laws around that and protections around that. That to me could make good sense. I think about on the private sector side, trust law in Wyoming. Wyoming is held out as having the best privacy laws around trust in the US, if not in the world. But that is something that you specifically set up for yourself, for your family, and then we protect it. Where I feel like we could get a bit overreaching or prescriptive in the law is when someone else has set up a service, you voluntarily go onto that service and utilize it. And then we're sort of reaching in and saying, hey, you can only do this, you can't do that. And by the way, that costs $1 for every time. But that to me doesn't seem like the right place to go legislate, and doesn't fit with Wyoming's sort of history. So I don't know where that leads, if it's maybe a little bit ahead of the evolution of this notion of KYC or data trusts. But I sort of had a realization today that there's a line between your own creation of your data and then Wyoming doing a very good job of wrapping that with privacy laws and protections. And if someone invades that, you have the ability to go after those folks under Wyoming law. And then sort of someone else's data that's been generated by you voluntarily participating in their platform.
Mhm.
Thank you, Mr. Chairman.
No, there's a big difference there. Absolutely. Additional discussion on that or any other points? Thank you, Joel. Any further thoughts? All right. Anything that we need, staff? Anything you need from us at this point in time?
Mr. Chairman, just to kind of review
Mhm.
what we've understood to be a directives to LSO this meeting. We'll be working on a reinsurance bill draft as well as a white paper for the committee.
Let's
Um,
let's keep the white paper short, though. I don't want it to be
I
a
can't
ton
make
of
any
work.
promises.
Yeah, let's just try and do a 3 page, 1 page, something with a little bit of background. I don't want to put a tremendous amount of work on, please.
Let's keep the bill to 1 page too.
Good luck. Yeah.
I didn't hear a specification on font, so we'll keep that in mind. Mr. Chairman, updates to the sandbox draft and the Dow bill draft, working on amendments for both of those. And then I think the intention was to create some working groups, but that isn't necessarily what we'll be doing, but
Right.
we'll be looking forward to seeing those coming from the chairman. So
Perfect. Excellent.
did I miss anything?
That's what I've got. Mr. Co-Chairman, anything that we missed there?
I feel like we have to have missed something because that wasn't very many bills for the blockchain task force.
I'm sure we'll sort something out.
We'll catch up later.
Well, we'll probably start working on a draft of digital identity, but it'll just coalesce over time. Anything else? Okay, thank you. Select committee, anything else for the day? Anything else? All right, seeing none, we are adjourned. Safe travels, everyone. Thank you for your participation.